Serial number is 21, my lord. Execution is filed against me, my lord. 21, my lord. And in trial court, views, my lord. And
Which list you are? Which is your list?
my word is totally right.
So, my lord, this is not even, my lord, what Mr. Diwan's clients, my lord, is facing, because that is the question of an individual or an entity or a constituent of a bank going to the bank with their currency and that being accepted. That's a different thing. Now, the DCCB is the bank surrendering the currency to the Reserve Bank of India. Now, there are, therefore, my lord, there are some which are in this list. There are some which is outside. My lord, your lordship have framed one question, but my lord, if your lordship wishes to keep the whole lot out, all I will do is, my lord, collect the particulars of the ones which are before your lordship today and hand it over to your lordship's officers, so that if your lordships wish to keep that apart, then the whole lot should go out along with the question number 9. So the DCCB issue will therefore not be, my lord, before the Constitution bench at this point.
May I just clarify, my lord, it's not the DCCB only, but it's the primary. Manjula ji was making submission on primary agricultural credit societies, my lord, at the primary level. What happened with them was that on the 8th, whatever cash they had with them on the 8th was not taken either by the DCCB or any, and they could not open their bank accounts in any other nationalized banks. So the cash that was left on 8th is the only one. That is what is an issue before in those cases, my lord.
Now,
The cash left on 8th because DCCB had instructions to accept only from the individuals and not from the institutions. So these were institutions that did not accept the cash which was left with them because of sale of fertilizers or some deposits that were made by the individuals in the society. Some societies have 6 lakhs cash, some have 8, 11, something 16, something like that, not more than that. All it is only about the cash left on 8th evening, not of 9th, 10th, or because 10th and 14th and others were taken care of by the. It's only with regards to the 8th that the issue. Because 10th and 14th and others were taken care of by the. It's only with regards to the 8th that the issue.
We will deal.
Just one line, my lords.
Huh.
The issue that would be before my lords would be whether it is reasonable not to allow us that the cash that we are left with on the 8th.
Huh.
Being DCCB not allowed to accept from institutions, we had only our accounts were only with the DCCB. We could have deposited only there. And since nobody was there to accept it, those cash is still left with us. And therefore we are before your lordship.
All right.
That is
my lord, the short answer, my lord, if your lordships are interested at this stage, everybody was allowed to deposit. They were not allowed to deposit in DCCB. They could have gone anywhere else and deposited.
That is exactly the case, my lords. We did not have accounts in any other nationalized banks. No nationalized banks at that point of time was opening fresh accounts, my lords.
I think we don't propose to go into all these factual aspects in this case.
No, it's only the reasonable, my lords.
Please listen to us. It is not that you are remediless. We will leave it to the division bench, two-judge bench, to decide all these factual aspects and including the whatever you are suggesting. And I really don't know whether the Supreme Court is a proper place for you to decide these factual aspects. Let us not lose focus on the important constitutional questions. Let us concentrate on that. Let us not deviate from that. Let us not deviate from that.
I just wanted to bring it that.
All right. Anyhow, we are not proposing to answer all these questions. These are all more on facts. Let us focus on the constitutional points raised here. We will answer that.
Why I'm saying it is important, my lords, is the RBI or the other institutions are trying to brush us aside, saying
That's all right. You can argue. You can argue all those things. After before the two-judge bench, you can argue all those questions.
What I just want to place before my lord's consideration is, my lords, all these submissions that we have got sufficient opportunity is not right in the sense that we all are left with the cash on 8th evening. That opportunity was never granted and we could not have done which I.
All right, we have understood. Yes, Mr. Gupta.
Now, my lord, coming back to the main issue, what I have done is, my lord, I have written down all the propositions which, according to me, my lord, are relevant. Now, many of these have already got addressed by the Attorney General, my lord. So, therefore, I will not be troubling your lordships with them. In some, my lord, I will supplement a little. But first of all, my lord, if your lordship permits, my lord, me to place this two-page only. These are propositions which, my lord, to my mind, my lord, covers the issues which have been raised by the petitioner. First one is the withdrawal of all series of two denominations, that is 500 and 1000, is well within the jurisdiction and powers conferred upon Reserve Bank of India by Section 26(2) of the RBI Act. Our propositions. Millard, I haven't put it as a question. I'm putting it as an answer. So, Millard, the first question is whether 26(2) covers what has been done in this case. That's number one. Number two, the submission that unless phrase any in section 26(2) is read as some, then the power conferred by the said section becomes unguided, uncanalized, and arbitrary, and that is without basis. That proposition is without basis. Then C, it is not correct to say that the process under 26(2) has not been followed in the present case. The procedure laid down has been followed, and the process cannot be criticized on the ground of any procedural lapse on the part of RBI or the central government. So therefore, my lord, the first two deal with the interpretation and constitutionality of section 26(2). The next one is, my lord, whether there is any procedural impropriety, which is well within, my lord, judicial review powers. Then comes, my lord, the arguments which relate to, my lord, actual judicial review of the decision. D, the decision to recommend and the decision of the cabinet to accept such recommendation is not subject to judicial review. That's our, my lord, contention. Then, my lord, in this sphere of economic policy making, the Wednesbury principles are of no or little use. The proportionality principle also cannot be applied to the judicial review of economic policy. My lord, I will, my lord, deal with, my lord, the internet judgments in this context. Then, my lord, without prejudice to the aforesaid, the petitioners have failed to establish that relevant factors have not been considered or that irrelevant factors have been taken into consideration. This is on the merits of. Then it is extremely important. I have kept it separate because this was a suggestion from the other side. It is extremely important that no restrictions are placed on economic policy making by RBI or the government of India by laying down guidelines, my lord, in a court. Because, my lord, that in the judgments, your lordships have noted that it is impossible even for the legislature or for, my lord, the government or RBI to envisage everything which may happen. So, my lord, when that is so, to lay down, my lord, judicial guidelines, my lord, would be extremely, my lord, dangerous in our respectful submission. Then, my lord, H. This now deals with, my lord, the SBN Act. I'll call it, my lord, the SBN Act because that's the act which came in 2017. The SBN Act has given relief to certain categories of persons subject to verification by RBI. Individual cases of hardships that have not been provided for in the Act cannot be gone into. RBI cannot, go beyond the Act also. I'll try to satisfy your lordship. Then the submission that section 4 of Act, it's Act, not articles, I'm sorry, Act 2 of 2017 is unconstitutional, is without any basis. And finally, my lord, it is well settled that the courts cannot issue futile or academic writs. It is also well settled that it does not issue a writ if it has become infructuous, and declaratory relief in such cases will not be given if it involves factual adjudication. Now, my lord, declaring a law to be unconstitutional is a declaratory relief which can be given at any time. But, my lord, to say that look into the facts of the case, judicially review based on the facts, and hold that that particular decision was arbitrary or whatever, that is an adjudication on facts. Once, my lord, that decision is not to be reopened. After that, my lord, it should not be adjudicated at this stage, my lord, is what I will try to show. Now, my lord, I'll go pretty fast, my lord, because if I come back to A, my learned friend, my lord, has already taken your lordship or given your lordship, my lord, a list of the cases. My lord, we'll also file a written note on all this, my lord, by tomorrow or day after, my lord. Your lordship has been shown that there are judgments of this honorable court which says that any usually means in common parlance any or all. Now, I just want to add two aspects, my lord, to the argument. The judgments are there, my lord, the same judgments which and in fact, my lord, three of them, my lord, we have put in a compilation which we have made, which we are handing up to your lordships in any event. The first three, my lord, are on that issue. Now, I want to add only two things here, Miller. The first is that my learned friend's contention is that it should be read as some specified series or some specified denomination. Now, what is that sum? Is it 1, 2, 3, all minus 1? Suppose all is 20, then 1, 2, 3, 4, 5, 6 up to 19 satisfies the definition according to my learned friend. It is only if it becomes 20 that it does not satisfy the section. So, my lord, to say that any means sum is, my lord, actually creating confusion in that section. The next question will be, what does sum mean? How many? Can I demonetize half the money? Can I demonetize 25% of the series? Can I demonetize 75% of the series? My lord, just can't be. So, my lord, that's why any means any and all of that. In fact, my lord, my lord mentioned this. There might be situations where all the money has to be demonetized. My learned friend, Mr. Chidambaram, has actually given what, according to him, are the two legitimate, my lord, instances where demonetization will take place. And one of the two examples that he has given is when the currency of the nation has lost all its value. When that happens, you will demonetize the whole currency. You won't leave a little bit of currency there. So, my lord, there your lordships are being invited to take away that power which permits the central government, on a recommendation of RBI, to advise that the entire currency has to be withdrawn. So, my lord, this is one aspect, my lord, which I wanted to point out. The second aspect which I want to point out is, my lord, your lordships have taken a decision in many judgments as to the role that RBI plays specifically. And what, even in the internet judgment, my lord, your lordship has dealt with it in great detail. And one of the aspects of the way your lordship has looked at RBI's powers is that because it is dealing with monetary policy making, therefore it should be, all its provisions should be given wide amplitude. And, my lord, for this purpose, my lord, if your lordship will only permit me to place this, the source case, there is the first time that this honorable court, my lord, dealt with the Reserve Bank of India's powers is, my lord, Joseph Kuruvilla. And, my lord, in my compilation, my lord, I put it at item 5. And if your lordship permits, my lord, I'll just take your lordship through one or two passages in that judgment. In the compilation, it is at page 162. My lord, the citation that I have given is, my lord, from a online web edition, my lord, which I hate, my lord, handing up to the court, my lord, but my lord, all our juniors prefer it because it's the easiest one to access. My lord, in any judgment, the easiest copy to lay your hands on is the SCC online web edition. That does not have a head note. And that, of course, refers to the other paragraphs don't match. We are not even sure that everything that is written there is correct. But, my lord, this is the easiest one to get hold of. Therefore, my lord, when I say we want to place this judgment, they have all given your lordship, my lord, the SCC online web edition.
Actually, SCC paragraph don't tally with the SCR or our AIR.
Yes, my lord, and SCR doesn't even have a paragraph. We have to go by placitum there.
But there is a judgment of this court which has appreciated, There is a judgment of this. This very question came up before this court.
Yes, yes.
Of SCC only.
My lord, your lordship knows that at one stage, the Supreme Court never accepted any citation other than SCR. But then, my lord, SCR fell behind the times. Then there was no option.
No, see, for instance, people like us, we put paragraph numbers properly.
Yeah.
SCC, in order to claim copyright, they alter the paragraph numbers.
Oh my God.
And the head noting is an incentive for people to read.
Yes.
Otherwise, 200 pages.
But now, I'm sorry to be wasting time, my lord, but
the copyright case in the High Court.
Yes.
And in order to get over that judgment, they started introducing head notes and then prefatory notes
Correct.
and all kinds of footnotes also.
No,
So
one
to say-
paragraph is split into 4 paragraphs.
Therefore, the paragraph, your lordships are right. Your lordships appreciated SCC, not SCC online.
Okay. Yes.
In fact, now, Millard, we are finding that SCC head notes are often, Millard, covering most of the judgment. The head notes are no longer, Millard, as pithy as they used to. Also to get over copy.
No, in one of the cases, the head notes ran to 183 pages.
That's correct, Millard. They were just extracts of large parts of the judgment. Good evening. It's at page 162, item number 5. To be absolutely, my lord, proper, the citation that I should give your lordship is 1962 supplementary volume.
Jaideep
3.
Gupta, before that,
Yes.
I just want to put it, let us be focused on the argument of the other side.
Yes.
See, their prime, see, they have no problem of your, functioning and all. There is no problem. The focused question is, central government, Union of India and RBI have not followed 26(2).
Yes. So
That
that's
is the question.
that's the third proposition,
Let us
my lord,
be
which I'm dealing
focused
with.
on the question.
Yes. But, my lord, my learned friend, my lord, has also, my lord, sought to argue both the first two questions, that you should give a limited construction to 26(2), and if you don't give a limited construction,
True.
then it becomes.
That also emanates from 26(2) only.
That's right. It's emanates from 26(2).
Yes.
Now, please see, my lord, para
And
14.
you have not followed the procedure prescribed in 26(2). That is the other question they have.
That's the third question.
Recommendation is.
That's the third question. Yes. Right, right.
Recommendation part.
I'll come
Let us focus on the questions,
Yes, my lord. That's why,
Let us
my lord.
not be-
That's why, my lord, I have given your lordship all the questions that I intend to address your lordship on.
All right,
And, my lord, some which I do not wish to address because the learned attorney has already said.
Yes.
Now, the Reserve Bank's powers came for consideration for the first time of the Supreme Court, my lord, in this judgment. And kindly come to paragraph 14 of this report, my lord, at page 167. And here I'm only showing this to your lordship because here also it was argued that it was uncontrolled and despotic and uncanalized powers were being given to the Reserve Bank.
Yes.
Now, kindly come to 16. Before we consider the arguments of two sides in detail, we wish to say a few words about the position of Reserve Bank of India in the financial affairs of India and also about its place in the scheme of the law. Well, I'm relying upon these passages to my lord, argue that the widest amplitude should be given to section 26(2) and that there is nothing unguided about it. These are the two propositions, my lord. The Reserve Bank of India was established in such and such, my lord. Then the history of it is set out. Then para 17. The functions of the Reserve Bank are generally indicated in the preamble as the regulation of the issue of the banknotes and keeping the reserves with a view to securing monetary stability in India and generally to operate the currency and credit system to its advantage. But to enable RBI to function in this manner, it had to be given other powers so that it may function effectively as a central bank. To this end, the Reserve Bank was given the right to hold cash balances, a right to transact government business, which was also its obligation, and to enter into agreements, etc., etc. And then, my lord, they could control the banks. Then 19, on the next page, the above analysis of some of the provisions of the RBI Act shows that the RBI has been created as a central bank with powers of supervision, advice, inspection over banks, particularly those desiring to be included in the second schedule, etc., etc. Then, just see, my lord, the last 5-6 lines. No doubt the members of the board are subject to removal, but neither integrity nor efficiency is secured only by such guarantee, and we have no reason to think that the Reserve Bank acted in this case or acts in other cases under pressure or from oblique motives, as was pointed out in another tribunal, etc. Please see this language of that extract, All India Bank employees. If it was not the Reserve Bank of India, the only other authority that could be entrusted with the function would be the Finance Ministry of the Government of India. And that department would necessarily be guided by the Reserve Bank, having regard to the intimate knowledge which RBI has on the banking structure of the country as a whole and of the affairs of each bank in particular. The position of RBI being such, as we have stated from the Reserve Bank of India, the next thing is to inquire as to its powers under the Banking Companies Act, etc. And if your lordship comes to page 171, para 25, last two sentences, 171, para 25, last two sentences, there is hardly any provision where the Reserve Bank's judgment is not made final vis-a-vis a banking company, except rarely where an appeal to the central government can lie. No useful purpose will be served in referring. Then, my lord, your lordships may, my lord, look at para 27, etc. I am not troubling your lordship with anything else here. Para 46 at page 179, and I'm only taking your lordship through all this because this is the source case. In the present case, para 46 at page 179, in the present case, in view of the history of the establishment of Reserve Bank as the Central Bank of India, its position as a banker's bank, its control over banking company and banking in India, its position as the issuing bank, its powers to license banking companies and cancel, it is unanswerable that between the court and the Reserve Bank, the momentous decision to wind up a tottering or unsafe banking company in the interest of depositors may reasonably be left to the Reserve Bank. No doubt the court has also, given the time, performs this task, but the decision has to be taken without delay, and the Reserve Bank already knows intimately the affairs of banking companies and have access to their books. If the court were called upon to take immediate action, it would almost always be guided by the opinion of the RBI. It would be impossible for the court to reach a conclusion unguided by the Reserve Bank if immediate action was demanded. But the law which gives the same position to the opinion of Reserve Bank is challenged as unreasonable. In our opinion, such a challenge has no force, etc. So therefore, your lordship sees, my lord, the position that your lordships have, my lord, acknowledged as far as the Reserve Bank is concerned. So if this is the position, my lord, and the second judgment, my lord, which I won't go into just now, is item 4, Peerless General Finance versus Reserve Bank of India, which your lordships have referred to in the internet case. We'll show, my lord, that when you construe a section which confers powers on the Reserve Bank of India, your lordships do it to give a wide power to the Reserve Bank of India, because these are matters which the Reserve Bank is best suited.
On the contrary, Mr. Gupta,
Yes.
their argument is otherwise.
Yes.
According to Mr. Chidambaram, everything to do with currency
Yes.
has to be with RBI. RBI has the supreme role in that.
Yes.
And therefore, this decision for demonetization
Yes.
should have emanated from RBI.
Correct.
But it has now come in a reverse direction. He has argued on the decision-making process
That's
that within 24 hours, the government writes a letter to the RBI. The RBI
Correct.
convenes a meeting of the board.
Well, that
Takes a decision within 1 hour. The
Yes.
Prime Minister announces it. That's
that's, my lord, if
therefore his basic condition is that the procedure is not in accordance with 26.
is not in accordance to it. So therefore, my lord, that is for him, my lord, it is an argument in the alternative, because in the first instance he says that you don't have that power at all. In the second,
The government doesn't have that power. he says.
Government, not RBI.
no, RBI does not have the power to recommend, and the government does not.
On the contrary, he says that it is the RBI who has the power to recommend. And the recommendation ought to have come from the RBI, not the other way around. That is what
No,
his
my lord.
position is.
I'm only subject to my correction from my learned
I
friend.
hope Mr. Chidambaram-
Any, according to him, is only some. So therefore,
No, there are three.
That is one of the arguments.
yes, of course, one of the arguments,
First argument is that read any in a limited manner.
limited manner. Yes,
If you can't read it any in a limited manner,
then it will become unconstitutional.
26.2 is vulnerable to vice of excessive delegation.
Yes, correct.
And the third one
Yes,
is that the procedure as prescribed under
has not been followed.
has not been followed.
Yes,
And therefore, though he also agrees that we cannot sit in an appeal over the decision,
yes,
but since the decision-making process is flawed,
yes. Therefore, there is a procedural
it
impropriety.
is liable to be
Quite right.
interfered with.
I have no difficulty, my lord, your
Actually,
lordship.
I think these are the three
Yes, correct.
positions.
Correct, my lord. So therefore, I now move on to the unguided and uncanalized power aspect, my lord. And I just want to say one thing about it, my lord. No, before that.
Central government via notification.
Yes.
It is possible for the parliament also to take the legislative route,
Yes.
but that is not the only route.
Well, that is
I think
that is precisely my
that
my
argument.
argument.
Argument must be understood, I think. It is not that parliamentary legislation is a mandatory way of doing demonetization.
Your Lordship is right. What I said was, there are two ways in which demonetization can be done. One is the 1946 and 78 example by legislation, where the RBI doesn't come into the picture at all. Parliament does it, and I can challenge it on the violation of 1419. That route was taken in 46 and 78. The other route, as my lady said, go through 26. But 26, I said, the process must start from the RBI. So there are two routes. I'm not questioning the two powers, two sources of power. One is Parliament by plenary legislation. One is under 26. And 26, my Lord Justice, did I summarize my arguments 1, 2, 3? The first argument and the second argument. But the most important was a decision-making process in accordance with 26.2.
Now, my lord, in the affidavit which my learned friend placed, it was stated that
Whose affidavit?
my lord, this is my lord, filed by Miss Kamini Jaiswal, which my learned friend placed in some detail, my lord.
No, that was not argued in all this. You please focus on whatever his arguments, you know. If something is not argued, we will not go into all.
I'm not
Please focus on these three
I'm
questions.
not asking your lordship.
Actually, frankly, there were no, what is that argument against RBI here? It was virtually against the Union of India, actually. There was nothing against you. I think you can straight away, you can accept.
On the contrary, he is pleading supremacy of the RBI in all these matters.
Actually, the argument, as my brother said,
Yes.
was supporting you. You are belittled, you are not taken into confidence, etc., etc.
Well, I'll just read one passage from this affidavit which my learned friend placed. It is submitted that Parliament has the same power in 1946 as in 1978 as in 2016. Nevertheless, Parliament concluded that the demonetization that was intended could not be done under 26(2) of the RBI Act and required separate legislation. In 1946 and 78, Parliament intended to declare all series of a specific denomination. Since that power was found to be not available in Section 26(2), Parliament passed a separate law on each of these two occasions. My learned friend's argument was, if I recollect, he said that why else? Why else would I legislate? If I had the power under 26, why else? Why would I go to legislature? Milord, there is a very simple answer to that. And that answer, Milord, is now been borne out by the records which he has himself submitted. You go to legislation when the governor, you do not want to have the governor central board's opinion, when you want to bypass RBI. And Milord, in both those two cases, your lordship has seen.
Governors were against demonetization.
Your lordship has seen that. In both those two cases, my lord, the Reserve Bank did not appear to be in favor of demonetization. Therefore, my lord, legislation. That's the reason. Not that they had intent, they knew that they didn't have the power under 26. So, my lord, I close this point, my lord, here and move on.
And also the legislation was in respect of all series of two particular
denomination, exactly like us.
That is why notwithstanding.
Notwithstanding, quite right, my lord. Notwithstanding 26, etc. And my lord, there are small arguments here, my lord, that if you go by way of legislation, then there is a debate. There is no debate because in every situation, you go by way of ordinance. You have to go by way of ordinance.
To only answer one question, perhaps.
Yes.
Whether you are taken into confidence or not, that's all by the government before demonetization.
Oh, that is fairly simple.
That is the only, that is their argument.
Right. So then, my lord, I'll move on to the third question.
Or as you read one judgment, you had some intimate knowledge.
Yes.
So there you read some judgment.
Yes, yes.
Intimate knowledge.
Lordship.
So you had intimate knowledge without.
So, my lord. Now, my lord,
You read one of the judgments.
therefore, yes, yes. I have only placed one judgment. That is that Kuruvilla judgment. Intimate knowledge, because my lord, that's what the Reserve Bank is required to do. This is their job. My lord, monetary policy, my lord, is the express mandate of this act, and monetary policy, my lord, includes currency management. So therefore, my lord, this power is given to RBI. RBI is the expert, which I'll show.
No, what I meant is intimate knowledge of demonetization, not intimate knowledge of your currency.
My lord, currency management includes demonetization. My lord, I think, my lord, the one argument which has not been made, and rightly so, is that demonetization, these three objectives have no nexus with demonetization. That argument has not been made. Because, my lord, demonetization is certainly one way in which these problems can be tackled. Whether it can be tackled well or it cannot be tackled well is a different issue. But it is definitely having nexus. So, now, my lord, as far as C is concerned, that it is my submission, my lord, that it is not correct to say that the process under 26(2) has not been followed. My lord, your lordship knows what has happened, my lord. The attorney has also indicated.
Yes.
Discussion started, my lord, earlier. Discussion started earlier, but my lord, demonetization is such a decision that this discussion will always be fragmented. You will not one day open a note sheet saying that whether to demonetize. Because if you open that note sheet, then immediately, my lord, this will become public knowledge. So therefore, my lord, you will collect information from here and there, and then, my lord, somebody will put it together at some senior level, my lord. That's the only way this thing can go ahead. So therefore, my lord, the discussions, my lord, appear to have started in February. But, my lord, now we come to, my lord, what is the requirement of the section? The requirement of the section is that the last two steps in this process is that there must be a recommendation from RBI and there must be a decision by the central government. These are the last two steps. Their affidavit says that the first step is RBI, because they say that if you read section 26, it has to be initiated by RBI. But that's where, my lord, the fallacy lies in my respectful submission. My lord, that was paragraph, my lord. We'll come to that. Where's that affidavit gone? You've taken it away. My lord, in the affidavit, my lord, the way that this argument came in was by saying that it has to be initiated. That is at page 8. I'm just reading, my lord.
He argued that.
Yes, your lordship remembers. So, my lord, my respectful submission is, if you look at 26(2), it does not talk about the process of initiation. It only says that it will not end without these two. There has to be the penultimate step is a recommendation. The final step is a decision by the central government. Now, my lord, a situation like this can be initiated in many ways. It can happen, my lord, it can happen suo moto in the RBI. It can happen because of some discussion or something has taken place on an international level. It can happen at the instance of a state government. Certainly, my lord, it can be initiated by the central government. Because what is happening is, the central government has a problem. Black money is a problem. It's a problem, my lord, which can be sorted out through the offices of RBI. But, my lord, it is a problem which affects the nation. Then, my lord, comes terrorism. Now, RBI is not, my lord, having intimate knowledge of terrorism. Facts have to come from somewhere. So, my lord, it is perfectly normal for the central government to raise the question. What do you think we should do? And then comes a recommendation. Recommendation can go either way. Your lordship is right. We could have said no. We don't think it is right. That is what happened in the last two demonetizations. Or we could have said, and in this case, we did say that very well, it might be appropriate to do it that way. And that, my lord, goes back to the central government, and the central government then says yes. Now, there also, my lord, the central government has a discretion. If I say go ahead with the demonetization, the central government may still decide that no, we won't, for some reason, because the language is may. Now, this is the process under the law, under the section.
Even if you don't recommend,
Yes.
still the central government may take the
Milord,
They decide to go ahead.
may decide, but it seems, Milord, that in that event, it might have to bypass RBI and might choose the legislative process. Milord, Milord,
If you read section 26(2),
yes. On recommendation of the central board, the central government may by notification declare. Now, it doesn't say, of course, what kind of recommendation, a positive or a negative recommendation. What will happen if there is a negative recommendation by the central board? The central government may do it still. That's why, my lord, the Attorney General said that because we are not faced with that fact, we are not required to finally take a position on that.
you
That's all.
decide on the basis of hypothesis.
That's right. It's a hypothesis, so therefore we don't have to go that far. Anyway, my lord, now, my lord, momentous decisions are taken in this court in a matter of minutes. Similarly, my lord, when the central board of the Reserve Bank sits, my lord, they are not going to start by taking a pen and paper and start writing down from scratch. My lord, they are, my lord, people drawn in from various, my lord, walks of life, and also, my lord, experienced members of the who have gone through the Reserve Bank of India. So, my lord, they have a certain amount of information readily available. Minutes are given to them, they take a decision. So, my lord, the recommendation is the decision-making process of the RBI. That can take place.
Compare
quickly.
this court, you know, with the RBI. Here we hear the lawyers in the open court and argue. And
Yes,
take a
yes.
decision.
Of course, your lordship hears us. But, my lord, that doesn't mean. No, my lord, I'm not, my lord, drawing your lordships into this controversy. What I'm saying is,
Mr. Gupta, for a miscellaneous day, we read how many days, you know, to get ready for the examination on that day.
very well, my lord, I won't go ahead with this analogy at all. All I'm saying is, my lord, that the time or the speed, my lord, does not itself mean that there's something wrong with the decision making. This process of demonetization, two aspects. One is, my lord, confidentiality has to be there, and speed has to be there. Without it, my lord, demonetization cannot possibly succeed. It's stillborn from the beginning itself. So therefore, my lord, the speed at which this decision was taken ought not to be.
What you're saying, you were consulted.
My lord, we gave the recommendation. There is a letter of the 7th in which, my lord, they have raised the question. My lord, these are in affidavit, my lord. We are not, my lord, going anywhere beyond the record. 7th, they raised the question, and then, my lord, there was a central board met, and when the central board met, they decided to recommend. And when that recommendation went to the central government decided to act. So the process was followed. Process is followed. You cannot say that the process is not followed. In fact, my lord, there is one other canard here, that there was no quorum, or that rather we do not know whether there was quorum or not. My lord, there was quorum, we have stated on affidavit. The quorum is decided by the regulations. That quorum was met. There's no difficulty with that. My learned friend also says that there were some vacancies in one category of, my lord, members.
Quorum is, I think, 4.
Quorum is 4.
And out of that 4, one has to be
from one has to be from that
C category.
C category, 81C.
81C. And there were only, according to him, there were 7 vacancies.
Yes.
And only 3 were filled in.
So therefore, my lord, one of them was there in the quorum. Now the vacancy in the other 7, if it does not affect the quorum requirement, then, my lord, the vacancy aspect cannot be an independent ground, because section 8.5 says that no decision will be called into question on the ground that there were vacancies in the board. So therefore, that's also, my lord.
If the quorum was there.
Yes.
Have you stated on affidavit that
I have stated on affidavit that the quorum was there. Sorry? Yeah. Both the affidavits said so. No, I'll show. look at regulation 8 and 10. That's only on quorum. My learned friend only handed up. What is regulation 8 and 10? They deal with quorum. And I'm saying specifically that the requisite procedure laid down on the section and with...
No, there is no dispute relating to regulation.
Yes.
The question is whether, as per the regulation, actual members participated in the meeting. This is their point.
I'm saying that the procedure required in that regulation has been done, met,
This is what,
was duly followed. We have said so.
How many members are present?
Right, my lord?
There should be no difficulty on at least telling us as to how.
Yes, my lord, there is no difficulty in telling your lordships, my lord. I'll put it on a sheet of paper and give it to you.
Whether any of those members present belong to that 81C.
Yes, there was a member from 81C as well. That's why we have said on affidavit that we followed the regulation. The regulation required that 81C member, that was followed. So, my lord, that was fishing, my lord, because my learned friend does not have any reason to say that the quorum was not met. Now, my lord, in these matters, my lord, the burden still remains with him to at least say that I know for a fact that there was no quorum. He doesn't say that either. He says, I don't know whether there was a quorum. So, my lord, it becomes a prejudicial argument only. It tries to throw the burden on me.
Satisfy your lordship.
Now, this is not correct. This is not correct.
Within his knowledge.
According to you, the presumption is that
Why is he not placing it before your
to
lordship?
be valid.
No.
And the burden is on the person who challenges the validity.
No, my lord. Your lordships,
I am not
your
even
lordship's
at this
judgments
stage-
all
I'm
say.
not even at this stage asking that he show it to me. That we will see, my lord, your lordship's will. Why does he not show it to you? Neither the learned attorney nor the RBI counsel are willing to share full papers with your lordship. What
Well,
are they
this-
holding back?
our-
What are they hiding?
No,
My lord, this is exactly, my lord, the kind of
Nothing is being
prejudicial
held back,
submission.
nothing is being hidden.
Show it to the man at the
Of
court.
course, I will show it to the court if necessary. The court asks for it.
all right, we will continue tomorrow, right? Tomorrow.
Yes.